name is Bonaventure. Welcome to our commercial law class. Today we are going to look at a topic known as resolving commercial disputes. When we look at such a topic, we will look at the problems associated with commercial litigation in relation to arbitration, mediation, and negotiation. We will begin by looking at arbitration. Arbitration refers to the settlement of a dispute, and a dispute can be of fact or a law or even a procedure between parties to a contract. And there is a neutral person who will be a third party in the arbitration process. And when you use an arbitration process, you don't resort again to court action. Therefore, arbitration is usually voluntary. But in as much as it is voluntary, it is sometimes required to stick to the rule of the law in the process of arbitrating. Therefore, the parties to an arbitration have to be bound by the arbitrator's decision. This decision of an arbitrator is known as the award. It becomes binding, it becomes a binding arbitration. The exact procedure to be followed is given usually by a country's arbitration laws or by the arbitration rules prescribed by the Arbitration Act. We have advantages of arbitration as a means of resolving commercial disputes as opposed to courts of law. One of the advantages is that it is time saving. It is a faster method of dispute resolution. It does not actually take long like in the normal court process. It is time saving as its process is short. It is also convenient because the parties themselves are allowed to determine the number of arbitrators to have, the venue of their proceedings, the language to use. They can even opt to use Kiswahili or English or any other language that they understand best. Also, the cost of arbitration compared to the cost of the court is a bit lower. So the cost also is an advantage when you opt to go for arbitration method to resolve a dispute. Expertise and specialization. Also in arbitration, the arbitrators are specialized in their field. Therefore, it becomes much easier than when you appear before another method another method to which you see the person to render the leadership of that arbitration is not qualified enough. But in most cases, those taking part in arbitration process are very qualified people. Very qualified. Also, there is also the issue of privacy. In an ordinary court of law, there is no privacy. Guys come all over the place wanting to hear what is going to be canvassed, what is going to be argued. But when it comes to arbitration, it is different. There is privacy. It is the parties concerned who attend the proceedings of the arbitration. Otherwise, other parties are not allowed to attend the sittings of the arbitration because they are not party to it. But in a court of law, members of the public can come and hear the proceedings of what the proceedings going on in a court of law, but not so in the arbitration process. Also, in the arbitration matters of resolving dispute, there is flexibility. There is flexibility. For example, even what has been argued can be repeated again, but in a court of law, it can't be that way. It is another legal process that you have to refer to and follow, which requires you not to. It becomes another legal process because the law may not require you to repeat again what the witness has said, unless there is a very big reason and must be lawful in order to be allowed to recall a witness. But not so in the arbitration, because in the arbitration, all parties are present and they have to be there until the conclusion of the process of what they intend to until what they intended to resolve is over. Is when the process can be deemed as discharged. Also, there is informality in arbitration. In arbitration, it's not like in a court of law where they have to follow so many formalities in order the case to take off. But in an arbitration process, it is very informal. People can talk the way they want to talk. It's very informal. It's very, very, very informal, unlike in the courts of law. But also, in as much as we have the many advantages in the arbitration process, there is also some disadvantages of arbitration as an alternative dispute resolution. It has also its own advantages, and we are going to look at these advantages. For example, if arbitration is binding, both sides to the arbitration process lose their rights to appeal again after the arbitration process is over. They are not allowed again to appeal. Once the arbitrator has given his verdict, that is the end of the process. One cannot come again and say he wants to appeal. No. Whatever comes out of that process is binding. That's one of the disadvantages. That once you have agreed to an arbitration process, whatever comes out from that process, even if it's not in your favor, You cannot go back to to a court of law and dispute the process because you agreed to it, and the verdict has, however bad it has come out not in your favor. You cannot go back to court and dispute what has been passed. It is final. So that is actually an advantage, because in court, if you don't agree with one court, if you don't agree with the lower court, you go to the next court. You go to the next court. And if the matter is complicated and the amount of money is modest, the arbitrator's fees may make the arbitration uneconomical. Sometimes you see, when it comes to a court of law, the amount that may be, because this is a civil case, the amount that the court may decide to award may be more. But when it comes to arbitration process, it may not go as per the rules of the court, because that's not a court. That's how the parties will resolve to agree. And that is where the disadvantage comes from. And also rules of evidence. In a court of law, they follow rules of evidence very much. But in an arbitration process, such evidence need not be followed. And as I said, it's very informal. In fact, they conduct their affairs in a very informal manner. And therefore, where the arbitration is, for example, based on a question of law, the arbitrators may not have for example, may not be expert in legal matters, or may not have sound legal knowledge to deal with the issue, some issues. But yet they will be allowed by the parties to arbitrate their dispute. And maybe the arbitrator has not actually reached to the requirement of an ordinary judge of the High Court. But still the same, he will be allowed to carry on the process, so long as the parties themselves agree. They agree with what they intend to solve. Then the arbitrator would have done his job. And also he does not actually use known rules in his work. He can just handle the matter the way he deems it fit for him, as convenient as possible for him, without following strict rules, like what is done in courts of law. But if also an arbitrator becomes rogue, he can also be removed from arbitrating that process. For example, if the arbitrator can accept a bribe from the other party, then the other party may go to a court and seek for his removal from conducting that process. It is allowed. Also, where he is an arbitrator and yet is interested in the matter that is being resolved. Is a party to the matter that is being resolved. Then he cannot be a fair umpire. So somebody may go to court and have him removed from arbitrating that dispute because he's an interested party. And where he has refused to proceed with the arbitration process, and yet the parties would like him to complete the process, then the parties concerned, or either party concerned, may go to court and also seek for his removal. It will be justified for such a party to go to court and seek his removal. That is how, those are some of the disadvantages that are found in the arbitration process. Also, in dispute resolution, we don't have only the arbitration process. We also have the mediation process. And in a mediation process, a neutral and impartial third party assists the disputing parties to negotiate an acceptable settlement of contested issues to avoid or overcome an impasse if the parties are unable to negotiate. If the parties to a dispute are unable to negotiate, then a mediator comes in between and assists him to arrive at an amicable conclusion, at a conclusion acceptable to all the parties. It is merely the intervention into a dispute or a negotiation by an acceptable, impartial, and neutral third party with no authoritative decision-making power. It is facilitated by negotiations. This man or woman has no power to force the parties, but he mediates in their talks until they see light and agree to resolve that. He assists these parties to resolve their dispute in an amicable way. That is the work of a mediator. The third party is not actually an intruder in the matter, but where the parties have failed to agree, then he comes in handy to assist them arrive at an amicable decision. And the advantages of mediation is this one. Mediation is actually not very expensive. It is relatively inexpensive. And also it is faster. Mediation is swift. Mediation process can be conducted very swiftly and arrive at a decision. The parties arrive at a decision. Mediation also allows parties to revise some of their demands, to seat some of their demands. But in a court of law, it does not happen that way. But the advantage of mediation is that some grounds may be ceded to allow a dispute to be resolved. In other words, sometimes compromise is necessary for a dispute to some kind of compromise, it's necessary for some issues to be resolved. So you will see that a mediation process is not like a court process. Issues can be compromised, other new issues can come in, but not so in a court of law. And also, when you look at mediation process, the agreements reached is acceptable to all the parties than in a court judgment. Because in a court judgment, two parties, one party will lose and the other one will gain. But in a mediation process, it's a win-win situation. Because whatever is resolved is for the good of both parties. But not so in a court judgment. A court judgment, there's no win-win situation. But in a mediation process, there is a win-win situation. Let us also look at negotiation. In the process of negotiation, there is no third party. The parties themselves agree to come and air their views as to how they see them. They ventilate until they agree on the way forward. So in a negotiation process, it simply involves the two parties. They interact with each other without somebody coming in as a third party to impose himself to them. No. They themselves will come up with a decision that they feel is proper for resolving their dispute. They themselves, without another party coming in, who may be biased, who may lean on the other side and favor the other side. So, in negotiation process, it's the two parties that come together and ventilate the issues and agree on the way forward and resolve their dispute. It sometimes leads to compromise, of course. Why? Because it proceeds with the exchange of information. So as the information is exchanged in the process, people see light and agree to some issues and sit their ground and come up with a resolution that will be acceptable to both parties. But also, in as much as I've said that the negotiation process has no third party to impose upon it, they themselves have to come up with they have to exchange information, they have to argue and see the way forward. So it has a disadvantage. It has disadvantages in many ways because one party cannot force another party to engage in a process of negotiation. So in order for two parties to come up and go for negotiation, it is not an easy matter without a third party. Therefore, sometimes it's not easy for two disputing parties to come together and resolve the matter. Two, sometimes negotiation may limit the parties' control over the outcome of the process. Why? They themselves sometimes don't know the outcome. But when it comes to mediation or arbitration, the third party will come up with an independent decision which he thinks would be useful in the resolving of the dispute. But you see, in a negotiation process, only two parties are involved. So even if they argue, even if they ventilate in whatever manner, they will not know the outcome. So sometimes the process may take long, unlike in mediation or in the arbitration. Also, negotiation, I would say, is a weak form of dispute resolution, and might be more valuable if other forms of say dispute resolution were to come in, like a mediator or an arbitrator. But you see, for two parties to agree, sometimes it's very difficult. Although it has got its own advantages, but it also has some disadvantages, like what I'm saying here. But because a particular negotiation may have a successful outcome, but not all. But not all. Sometimes it may have a successful outcome, but it may be so to the advantage of the other party. One party may outwit the other in knowledge, and the other one may succumb to what the other party is saying. Whereas, maybe it's not so, or it should not be so. So you see, a weak party is disadvantaged in negotiation because there's nobody to put matters straight. Also, people may choose to go for negotiation with a hidden agenda. They may go for negotiation in order to kind of stall the process. They may want to stall the process by opting to go for negotiation, so that it will take a long time as people buy time, because there's nobody who controls them. There's nobody who tells them that enough is enough, let us stop there. No. So sometimes it is a way of stalling the process. It's a way of stalling the process. However, not all this mechanism of resolving disputes bad. It has also its advantages, and it has also its advantages. For example, they are usually faster. The arbitration, the mediation, and a bit of the negotiation. They are a bit faster at resolving their disputes. And also people have a chance to tell their story in the correct fashion for people to understand. Unlike in courts where you are restricted. But when it comes to this arbitration and negotiation and mediation process, people have the right to argue the way they want to argue. But in a court of law, you cannot do so. Time is limited, and you are also restricted of speaking what you want to speak, unless it is within the law of the court. And in a court of law, disputes are formal. But in these other processes of alternative resolution, the process is very informal. It can take any form. People can discuss even in their own language, the language that they understand, but not in a court of law. In a court of law, matters there are very formal. Very, 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 very formal. But not so in these other alternative resolutions. Also, in a court of law, matters are not confidential. The newspaper men will be there, the media will be, or what I mean is that the media houses will be there to report on the matter, but not in the arbitration or mediation or negotiation processes. It will be, privacy will be maintained there. Unlike in courts where members of the public come and witness what is going on. So it is not lost on us that if we don't want to go to court, we can use these other means of resolving our issues, and which will not be very expensive compared to the courts of law, and which will not waste much time compared to the courts of law, and which will be very informal compared to the courts of law, and which will also make the parties involved in their process enjoy what we call a win-win situation. But when it comes to a court of law, there must be a loser and a winner, but not in the mediation process. Mostly, it's a win-win situation. And where there is a situation where one party feels that it has been outwitted by the other party, then such cases are very minimal. They are not as high as in courts, but in courts there must be a loser and a winner, but not so in these other dispute resolution mechanisms. Therefore, my good students, I would like to implore you to look at your books again and review what I've taught you, especially looking at mediation, looking at negotiation, and also looking at arbitration, with a view of comparing these other alternative methods of dispute resolution and the normal methods that is usually done by courts, and see which one works for you. But what I know is that both courts and these other dispute resolution methods, we cannot do without the other. They have to go, we have to work. They have to work hand in hand with the courts. Because if you really don't agree completely with what has come out of an arbitration and what has come out also of a mediation, then you can go to court. So long as the mediation process was not binding. Because if it's binding, whatever resolution is comes out, you have to agree with it. So my good students, with that we come to the end of our lesson. Until next time, goodbye.